students. This is Srikanth signing in for contracts 1. Since in our previous class we are seeing about consent as well as free consent. So when consent is said to be free, consent is said to be free when it is not caused by flaws in the consent, that is coercion as defined in section 15, undue influence, fraud, misrepresentation and mistake. If all these flaws are absent, then consent is said to be free. So consent is said to be free when it is not caused by flaws in consent. And we have seen coercion. What is the meaning of coercion? Then undue influence, fraud we have seen, misrepresentation we have seen, and today we are going to see about mistake. So this mistake has been defined under sections 20, 21 and 22. So mistake, the meaning of which may be defined as it's some erroneous belief, that means wrongful belief about something. So it's a wrongful belief, even you don't know about that thing, you assume that it is correct. According to section 20, it is an erroneous opinion as to the value of that thing which forms part of the subject matter of the contract. It's an wrongful opinion as to the value of the thing, and that thing forms part of the subject matter of the contract. For example, A is there, B is there. A wants to sell his house to B, and B wants to purchase the house with respect to C. Here, both are under a mistake that they have attained consensus ad idem. In fact, it is an erroneous opinion or wrongful opinion. So, in fact, mistake can be classified as mistake of fact. Section 20 speaks about this, and mistake of law. Section 21 speaks about this. So mistake means wrongful opinion as to which, as to value of the thing which forms part of the subject matter of the contract. And mistake is divided into two types. One is mistake of fact, another one is mistake of law. So we are going to see what the mistake of fact speaks about. Section 20 speaks about mistake of fact. So this has been described and elucidated under a well-known maxim, ignorantia facti excusat. That means ignorance of fact excuses. Normally what happens, if there is anything with respect to law, ignorantia, law unexcuses, law don't excuse if you don't know about the law, but law will excuse if you don't know about the fact. This is what this maxim speaks about. Ignorantia facti excusat, it means ignorance of fact excuses. Where there is a mistake as to the fact material to the contract, it is called a mistake of fact. Where both the parties to an agreement, they are under a mistake as to the matter of fact essential to the agreement is void. Here what happens is, A agrees to buy an article from B, right? A agrees to buy an article from B. B, when he is selling the article, there is a defect in the article. A don't know about the defect in the article, even B don't know about the defect in the article. So at the time of contract, it is found defective. So now Neither of the parties had knowledge as to this fact. Even A don't know about the defective, B don't know about the defective. So it's a fact. So the agreement is void. So ignorantia facti excusat. So mistake of fact, mistake of law. Mistake of fact means it is a fact with respect to subject matter of the contract. Again, mistake of facts are divided into again two types. We will see what it is. So, mistake of fact is of two kinds. One is unilateral mistake, another one is bilateral mistake. Unilateral means one sided, bilateral means both sides. In a contract, if a mistake arises with respect to one of the party, it is known as unilateral mistake, and if a mistake occurs upon both the parties, it is known as bilateral mistake. So, unilateral mistake means mistake exists on either of the parties to the contract. Let us see one example. A agrees to purchase a radio from B, thinking that it is a new one. A wants to purchase the radio from B, so he thought that the radio is very new one. In fact, it is not new. It's if A's erroneous belief that radio is new was not known to be, A cannot avoid the contract. So, if A's mistake was known to be, then A can avoid the contract. Here, what happens? A wants to purchase the radio from B, assuming that radio is new. In fact, radio is not new. In fact, radio is not new. This fact does not come to the knowledge of B, then A cannot avoid the contract. If it comes to knowledge of the B, then A can avoid the contract. Unilateral mistake means mistake only on one of the parties. Then bilateral mistake. So mistake exists on the part of both the parties to the contract. Bilateral means both. Here A agrees to buy an article from B. Both the parties, that means A and B, are aware of the fact that article is defective. It is a bilateral mistake and it is void. So now you have understood that mistake means mistake is of two types, mistake of fact and mistake of law. We have seen mistake of fact. Again, mistake of fact is divided into two types. One is unilateral mistake, another is bilateral mistake. Unilateral mistake means mistake exists on one of the parties. Bilateral mistake means mistake exists on both the parties. Now we are going to see mistake of law. Now, ignorantia juris non excusat. It's a popular maxim. Ignorantia juris non excusat. It means ignorance of law is no excuse. Ignorance of fact is excuse, but ignorance of law is no excuse. Other words, a party cannot get any exemption from the act done in ignorance of law. It is called mistake of law. For example, if you give money and take promissory note, you have to sue upon the promissory note within 3 years. That is the law. After expiry of 3 years, if you go to the court will say it has barred by limitation. So we are unable to help you. Court won't take your case. Why? Because time has barred, 3 years has been went. That means if you say I don't know about the law, Then court says ignorance of law is no excuse. Now you cannot plead that you had no knowledge as to the law. Law தெரியாதுன்னு சொன்னா கோர்ட் வந்து ஹெல்ப் பண்ண முடியாது. ஃபேக்டில் ஏதாவது மிஸ்டேக் இருந்தால் கூட கோர்ட் ஹெல்ப் பண்ணும். லாவில் மிஸ்டேக் இருந்தால் కోర్ట్ వోంట్స్ హెల్ప్ యూ. ఫ్యాక్ట్లో ఏదైనా మిస్టేక్ ఉన్నా కూడా కోర్ట్స్ హెల్ప్ చేస్తాయి. కానీ లా తెలియదు అంటే చట్టం ఒప్పుకోదు. ఇఫ్ యూ గో టు దుబాయ్ ఆర్ అవుట్ సైడ్ కంట్రీస్, యూ హ్యావ్ టు నో అబౌట్ దేర్ లా. If you tell that I don't know about the law there, they will tell ignorantia excusat. This law, ignorantia juris non excusat. Ignorance of law is no excuse. So you have to know the law. Now you have know that consent is said to be free when all the flaws or consent is absent. So we have seen all the ingredients. So coercion should not be there, undue influence should not be there, fraud should not be there, misrepresentation should not be there, and mistake should not be there. When it comes to mistake, mistake of fact, mistake of law. Again, mistake of fact, unilateral mistake, bilateral mistake, then mistake of law. So this is with respect to free consent. In our next class, we will move on to another chapter. Good day, children. This is Srikanth signing off today.